federal bankruptcy judge looked down from the bench, heard the bank's repossession request, and said one word. Denied. No explanation. No appeal. Just denied. That single ruling set off a chain of events that would leave a totaled, undrivable car sitting in a driveway for over 2 years, a landlord's patience wearing thin, and one man completely at the mercy of a bank that won't pick up the phone. Here's the full story. Our story takes place in Illinois, starting in 2020. A young man, we'll call him Marcus, finances a high-performance vehicle, a Dodge Hellcat, 717 horsepower, a sticker price north of $65,000. For 2 years, Marcus makes every payment. His credit is intact. His life is on track. Then 2023 arrives and everything changes. Marcus's mother is diagnosed with cancer. The medical bills accumulate faster than any savings account can absorb. Within months, Marcus finds himself $15,000 in credit card debt, every dollar spent trying to keep his family above water. Facing no realistic path out, Marcus does what the law allows. He files for Chapter 7 bankruptcy in the Northern District of Illinois. Then, in early 2024, Marcus gets behind the wheel in the rain. The Hellcat is running slick tires, high-performance track tires not legal for public road use in wet conditions. On a rain-soaked Illinois highway, the car clips a guardrail. The damage is catastrophic. The Hellcat is undrivable. And because Marcus was at fault with illegal tires, his insurance won't cover the full loss. In one moment, the car becomes worthless. Let's pause and look at this from Marcus's side. His mother's illness forced the bankruptcy, not recklessness, not fraud. The accident, while his fault, happened during the most financially and emotionally crushing period of his life. With the car totaled and bankruptcy protection active, continuing payments on a vehicle he couldn't drive felt not just financially impossible, it felt absurd. Put yourself in his position. What would you have done? Now consider the bank's position. They financed a $65,000 vehicle. That vehicle is wrecked. The borrower filed bankruptcy. Insurance won't cover the full gap. The bank is owed money on collateral that no longer functions as collateral. Their move is entirely rational. File a motion in bankruptcy court for relief from the automatic stay, a formal request for permission to repossess the vehicle and recover whatever value they can. And here is where this case takes its strangest turn. The bankruptcy judge denied the bank's repossession request. The reason was never explained. Not to Marcus. Not clearly to his own bankruptcy attorney, who had told Marcus before the hearing that the bank absolutely had the right to repo at any time. Yet the judge said no. One ruling, no explanation, and a totaled Hellcat became legally untouchable. Months pass. The wrecked Hellcat sits in the driveway of the home Marcus rents. His landlord, a patient, generous man by all accounts, says nothing at first. But as 2024 becomes 2025, even patience has a ceiling. The car isn't just an eyesore, it's a liability, a question mark. And Marcus, who would love nothing more than to remove it, legally cannot. The car is frozen in place by the very law meant to protect him. Before we go further, let's understand exactly what the automatic stay is, because it's the legal engine driving everything in this case. When someone files for bankruptcy, federal law immediately issues what's called an automatic stay. Think of it as a court-ordered pause button. All collection actions, lawsuits, wage garnishments, and yes, repossessions must stop instantly. Creditors who want to act must petition the court for an exception. That petition is called a motion for relief from the automatic stay. Now let's talk about liens. When you finance a vehicle, the lender places a lien on the title, a legal claim that says, "We own a piece of this until you pay us back." You cannot legally sell, donate, junk, or transfer the vehicle until that lien is formally released. In Illinois, under State Statute 625 Ilks 5/3-116, a lien holder is required to release that lien within 21 days of full payoff or debt forgiveness. 21 days, that number matters. In September 2025, over a year after the crash, Marcus receives a letter. The bank has decided to forgive the remaining loan balance entirely. Just like that, the debt is gone. 2 months later, in November 2025, a check arrives from his GAP insurance provider. GAP, Guaranteed Asset Protection, covers the difference between what you owe and what the car is worth at total loss. With the loan forgiven, that remaining balance came directly to Marcus. For the first time in 2 years, there's a light at the end of this tunnel. Marcus calls the bank's bankruptcy department immediately. He requests a lien release, the document that will allow him to obtain a clear title from the Illinois DMV and finally remove the car. The bank confirms, 10 business days, the paperwork will arrive by mail. Marcus waits. 10 business days pass. The mailbox is empty. Marcus calls again. The representative apologizes. The first request was never properly submitted. They'll resubmit it correctly this time. Another 10 business days. Marcus waits again. Nothing arrives. A third call produces a new explanation. It's actually a lengthy process, but the paperwork should arrive the second week of January. January comes and goes. Still nothing. 3 promises, 3 missed deadlines, 0 documentation. Here's what makes this maddening from a legal standpoint. The debt was formally forgiven in September 2025. Under Illinois law, the bank had 21 days, roughly 3 weeks, to file that lien release. We are now months past that deadline. Marcus isn't just dealing with slow bureaucracy. The bank may be an active violation of Illinois state statute. And yet Marcus feels powerless because calling the same phone number keeps producing the same result. Nothing. And the stakes are now real. Marcus's lease expires in 8 months. When he moves, he cannot abandon a vehicle on his landlord's property that exposes both of them to legal liability. He cannot junk the car without a clean title. He cannot sell it, donate it, or transfer it. His landlord, patient as he has been, is running out of runway. What started as a legal protection has become a legal trap. What would you do in this situation? Let's look at this from the bank's perspective one more time, because fairness demands it. The bank ultimately forgave a balance they were owed. They didn't have to do that. They absorbed that loss. The lien release process, especially in a case that wound through federal bankruptcy court, does involve additional administrative steps that a standard payoff does not. It's possible, not excusable, but possible, that the delays are genuine procedural complications rather than deliberate stonewalling. But that charitable interpretation expires at 21 days under Illinois law. After that, the explanation doesn't matter. The obligation exists regardless of internal process, and in consumer protection law, ignorance of your own procedural timeline is not a defense. The clock started in September 2025. It is still ticking. So what are Marcus's actual options? First, stop calling the general line. Draft a formal written demand letter citing Illinois Statute 625 Ilks 5/3-116, sent via certified mail to the bank's legal department, not the customer service center. A letter with a statute citation creates a paper trail and signals you know your rights. That changes conversations. Second option, file a complaint with the Illinois Secretary of State's office, which administers vehicle titles and has authority over lien release compliance. Third, contact the Illinois Department of Financial and Professional Regulation. They oversee state-chartered banks and take consumer complaints seriously. Fourth, and most powerful, consult a consumer protection attorney. Many handle lien release violations on contingency, meaning Marcus pays nothing unless they win. There's also a fifth path that most people don't know exists. Illinois law allows a vehicle owner to petition the court directly for a court-ordered lien release when a lien holder fails to comply. This is a relatively simple motion. A consumer attorney can file it in a matter of days. The court can compel the bank to act, and if the bank continues to delay, the judge can impose sanctions. The same legal system that created this problem has the tools to resolve it. This case, quieter than a custody battle and less explosive than a criminal trial, reveals something important about how the law actually functions day to day. Bankruptcy protection saved Marcus from the immediate crisis, but it also created a legal status for a piece of property that no one, not the judge, not the bank, not Marcus's own attorney, fully thought through to its logical conclusion. The system worked, and then it left a man alone with its paperwork. As of today, the Hellcat still sits in that driveway. The landlord is still waiting. The bank has still not produced a lien release. Marcus has 8 months before his lease forces a resolution, one way or another. He came to the internet asking if he was simply at the bank's mercy. The answer is no. But exercising his legal rights will require more than phone calls. It will require putting the law in writing and making the bank answer for it. What this story teaches is that legal resolution and practical resolution are not the same thing. A debt can be forgiven. A bankruptcy can discharge. A judge can rule, and still, a man can spend 2 years anchored to a 4,500-pound monument to bureaucratic inertia. The law gave Marcus protection. The law also handed him a puzzle. The question is whether he chooses to use the tools it also gave him to solve it. If you or someone you know is dealing with a lien release dispute, a bankruptcy complication, or a lender that simply won't respond, we've linked a step-by-step consumer rights checklist in the description below. It covers your exact rights under Illinois law and the Federal Bankruptcy Code, the agencies to contact, and the letter language that actually gets results. If this case fascinated you, our next video covers another Illinois bankruptcy ruling where the judge's decision had consequences no one in that courtroom anticipated. Hit subscribe, drop a comment telling us what you would have done differently, and we'll see you in the next one.